Hello, everybody.
Judge Chris emailed about 10 minutes ago saying that he's going to be probably a few minutes late because he's in a Sedgwick County hearing. But I don't know that his client is on here yet.
Did I order her to appear at the courthouse?
Judge Webster does at the time of first appearances, but
Okay.
I put that in the when the link is sent out, I also put that in there so that counsel know as well.
Webster did order him to be at the courthouse because I generally write it in my notes.
Oh, I'm sorry. Kayla is a him.
No, her, sorry.
Okay.
Yeah, was ordered to be at the courthouse for the sentencing, for the revocation.
All right. Oh, I'm right here.
Okay, very good. So we're waiting on your attorney. So I'm going to turn my video and audio off. You can, there we go. That wasn't too late, Mr. Pate. Do you need time to confer with your client before we get started?
No, Your Honor, I discussed with her everything yesterday, so we're ready to go.
We're going to go on the record in State of Kansas versus Kayla M. Connor, 18 CR 214. This is a old case. The state appears by and through Ms. Gillette. Ms. Connor is appearing apparently on bond, and she is at the courthouse as directed for a revocation hearing. It looks like she's being supervised out of the 31st Judicial District, and we have Ms. Strode, who is appearing, as well as Mr. Ed Ketley, who is the Director Supervisor of Community Corrections for the 13th Judicial District. Okay, it looks like I have in my file August 22nd, 24, test positive for methamphetamine, May 2nd, May 6th. She did a voluntary 2-day sanction in the Greenwood County Jail, but then it's alleged that after that, she tested positive for meth and she was unsuccessfully terminated from drug court and still owes money. Mr. Pate?
Your Honor, I have discussed the allegations and the motion to revoke probation that was filed on August 1st. Ms. Connor intends to waive a right to a hearing and admit that she's in violation of her probation.
Ms. Connor, is that correct?
Yeah. Yes.
Okay. I will find that by voluntary waiver of hearing stipulation, she violated her community corrections and asked for recommendations from the state.
Yes, Your Honor. Well, there are, I go in and look up the history of everyone when they come in to do their probation revocations. And in this matter, there are non-jail sanctions of extensions for not completing Senate bill treatment. There are sanctions. There were 4 sanctions done total. She was supposed to be transported to treatment, did not complete treatment, left, and still had done treatment and still not paying. When she had multiple revocations, she has done voluntary sanctions versus coming before the court. We have a waiver of probation violation hearing July 18th. She did 2 days beginning July 7th, or sorry, 3 days beginning July 17th. She did a drug court commitment, and she did a drug court sanction. That was issued September 27th. In journal entry of modification, because she hadn't completed her Senate Bill 123, she extended from December 17th of 2022 to December 17th of 2023. Then she agreed to another extension instead of having a revocation from December 17th of 23 to June of 24 to try to complete her treatment and pay her fees. And then she extended from June 17th to September 17th of 24, this time period, and she still had not completed her substance abuse treatment. Now, there was when they do drug court, Judge Kreitz works and works and works and works with them over there in the 31st. I came from the 31st. I know the first program.
I'm glad. Hang on. Show me where I ordered that she complete their drug court.
There's I thought there was an order modifying currency supervision to the 31st Judicial District. You shall comply upon with the following special condition of probation that you be imposed by the court if you were sentenced in that district to successfully complete the 31st Judicial District Drug Court Program. It's hand signed during the shutdown and filed October 7th of 2021.
But it didn't come from me. It wasn't an order from me.
It has your signature on it right here. You signed it and filed it October 7th of 2021.
I brought this up before. I'm just not sure where my jurisdiction is to enforce non-compliance with the program that's not in our district.
Right, but you assigned it to her in 21. There's an order in the court in the Odyssey file.
Okay, go ahead.
Okay. So she was supposed to comply with that program as well as her regular supervision. Even if you take out the drug court issues, she continued to test positive. She got 3 extensions versus coming back before the court for a revocation to try to still complete sentencing or substance abuse treatment. And I read those dates off straight out of the orders that are her voluntary extensions that she signed. All of them look like this. They're filed in the file. They contain her signature and they're electronically approved by you on the cover sheet. So there are 3 extensions for her, which are considered a sanction of an extension versus a revocation because they're voluntary. She has been given significant amounts of time with these extensions to complete her substance abuse treatment. She has done none of it. She has intentionally non-complied with the Senate Bill 123 treatment throughout this entire time period and not completed it. The one time she went, she walked out and left early and didn't stay. So I don't have any choice with her sanctions, her extensions, the intentional non-compliance, the leaving treatment, non-compliance with drug court is on top of all that. And if you complete drug court, you get incentives. You stay clean for a certain amount of time. They give you gas cards to get to and from drug court. They do other rewards. They have a wonderful graduation. And I've attended graduation as one of the support people for someone going through the drug court program over there. And I still check in with that person today. Julie says, I don't know that she left treatment, but she was supposed to go to treatment. But she is just materially non-compliant. She is not doing everything that she's supposed to do over there. I don't know how else we can help someone when we've extended her 4 times, and she's has voluntary sanctions, and we're here before the court, and she's still not complied.
What is her controlling sentence?
24 months.
Okay, and what is her jail credit?
she had 2 days at the time that she was sentenced. She would be entitled to her 3-day sanction that she did with us over here at Greenwood County. I believe she was ordered October 3rd, 2022, to do a sanction over at, oh no, that's a transport order. They transported her to treatment. So she's, I don't know what else that we can do to help her. We're at a point where she has a few days of sanctions and original time in.
Okay, so your recommendation is that she be revoked in order to serve her sentence.
Intentional non-compliance.
Mr. Pate.
Well, a couple things, Your Honor, and this is an old case. It's a 2018. It's not quite as old as it looks. She wasn't sentenced until June of 2021. That's still pretty old, but during that intervening 3-period time, there was a motion to suppress. I believe I was not the first attorney on this. That had to be relitigated twice. And then we had the COVID shutdown, and that ground everything to a standstill. So she was sentenced in June of 2021. Ms. Gillette keeps talking about Senate bill. I don't think this is a Senate bill case, Your Honor. I don't think she screened in for it. It's not checked on the journal entry of sentencing. Is a Senate bill case. It says additional comments in the journal entry, AA or NA 2 times a week, which Ms. Connor told me she still is attending group. UA within 2 weeks, as long as defendant stays negative, no extra treatment. Obviously, she had a positive. And then it goes on to say if defendant is positive, can be ordered into inpatient, mental health a requirement, defendant pays $75 per month. So because these were all kind of voluntary things, there really wasn't any attorney involvement. And I hadn't touched this file since October of 2021. So I think the drug court thing was probably as a result of those positive tests. So I don't think we're getting into all this material non-compliance stuff with the Senate bill case, because for whatever reason, this wasn't a Senate bill case. And I don't know if it was because of prior convictions or she just didn't screen in for it or what it was, but it wasn't a Senate bill case. Senate bill might have been good for her. A lot of these extensions, as I understand it, it wasn't necessarily because she was violating, she was still in treatment. She did test positive in July. We've admitted to that. That's obviously not a good thing. We've got to get this done. Ms. Connor tells me if she was UA today, it would be clean. She has not been ongoing using. So if the court wants to order that, she's willing to do it. And she says it'll be clean. She, I believe, is a manager at Casey's over in Iola. And the other issue, this case is so old, it's still on the old sanction track. So even if she's had the dip, this is a case that requires the 120 or 180 day dump. Because I believe that was all changed July 1 for cases that were committed on or after, I believe, July 1 of 2019. I'm going to look back and verify that in my guidelines manual here. Yeah, July, for a crime committed prior to July 1 of 19, it's subject to the old sanction track. So even if the court doesn't think a dip is appropriate, I think a dunk is required rather than outright revocation. What Ms. Connor needs to do is complete treatment and stay clean. Prison isn't going to serve anything other than a punitive effect. And obviously it would force her to not use for a period of time, but then she's going to get right back out and be to square one. So I would ask for either a dip or a dunk. And I think the dunk is a requirement before she can be outright revoked.
Well, it's been a while since I checked with the Department of Corrections to see how they're handling that, since they really kind of shut down that process. So I don't know what they do with people when they show up, since that was such a short-lived thing because they realized just buzzing people in and out of the DOC for short stints was not productive and very costly. Mr. Catley, what recommendations do you have?
Your Honor, I would agree with the state. She's had multiple opportunities, and I believe ISO Strode can even give more light on the subject. I think she's struggled the whole time she's been on probation.
Okay. Ms. Strode?
So Your Honor, Kayla's a Senate bill case. She's been paid by Senate Bill 123. She was put in our drug court, in our judicial, we have a judicial order in our district that basically says if you're a mandatory drug case, which she is a mandatory drug case, she does screen in for that. We require them to be in drug court. So she has been in our drug court program for multiple years. We have worked with Kayla. And we ultimately made the choice to remove her from the program because we had a lot of issues. Our biggest issue with people is lack of honesty. So if Ms. Connor would have came to us and told us, hey, she wasn't doing well, we would probably have taken a different path, such as inpatient treatment. Again, she did go to inpatient treatment. She did successfully complete it. She then came back out and she's continued to use and not do what she's supposed to and evade me. And so she has been going to treatment. Since she has been out on bond, my biggest concern is since she's been out on bond, I was hoping that this would be a big wake-up call to Miss Connor to get her to wake up and understand the seriousness of her situation. And unfortunately, in the past 2 months, she has made it to drug treatment group 1 time. And that is with my treatment provider knowing that her Senate Bill 123 funding is gone and still willing to work with her for free. Or if since she has state insurance, they were going to waive it. I finally, after it's been I had issues with her reporting for about a month's time and finally was able to connect with her. I've seen her a couple times this month. That's it. Really didn't get to see her much in August. She did have some sickness here and there. But when I called the doctor's office and finally had to force the issue, I found out that it was just a common cold and there was no reason why she couldn't come and see me. They told me it was the rhinovirus. So I just have some big concerns with Miss Connor. I mean, she does show times of positiveness and does what she needs to do, but she just seems to struggle.
And Judge, she has 4 jail sanctions with a total of 7 days that have been issued by the CSO or drug court.
Okay, so Ms. Gillette, as an officer of the court, I want you to look at the journal entry and look at the PSI because I don't have those in my file here. And tell me, was she a Senate bill case that qualified by law and was mandated to complete Senate bill treatment or not?
So drug treatment wasn't checked as mandatory and she was given up to 18 months supervision to do treatment. That was on the PSI. On the actual journal entry, the notes say AA or NA 2 times per week, UA within 2 weeks as long as the defendant stays negative, no extra treatment. If positive can be ordered into inpatient. Mental health, a requirement. Defendant should pay $75 per month.
And that's my question, Judge. I don't see in the PSI or the journal entry or my notes anywhere where Senate bill was ordered. And to my knowledge, that Senate bill is not something that gets added as a voluntary modification of probation. So if it was a Senate bill case, I don't know how it became a Senate bill case, or maybe these are the worst notes I've ever taken from a sentencing, but it's not in the journal entry.
Okay.
Your Honor, I'm looking at the PSI and under the defendant's version, it says in here that the Senate Bill 123 assessment was performed at that time and that it was found that she was not needed for treatment, but was rather referred for mental health treatment. So that was the reason why she was initially not recommended, was because she wasn't needed. But with Senate Bill 123, if they test positive, we can go back and we can reapply for Senate Bill, which is what we did in her case.
Okay. Ms. Connor, is there anything that you want to say?
Yeah. When I went to rehab in October 3rd, I had been clean for over 15 months. So I didn't struggle the whole time. I was compliant.
I lost my mom during that time. And I stayed strong. I'm the only one that my little girl has. And I'll lose everything, my job, my car, my house. So I'm really, I don't know. I've been trying to stay positive, but it's really hard when I should have graduated many times and I stayed in it on my own decision and Julie's to help better my chances of getting my son back. And when I didn't get him back, it was hard. I slipped up. And that was the one in July.
Okay. Well, I think you've had all the chances that we can afford you. I'm going to order that you do 180 days in the Department of Corrections as what they call a dunk, and terminate your case and turn your costs over for collections.
Are you wanting the 180 days in the jail or to?
No,
pay
I do the jail. I can't do for 180 days in jail.
Okay.
So you're getting,
Here, we gotta dot our I's and cross our T's. And I want to make it known that without having a hearing, I don't want to order drug courts in other jurisdictions, because I'm not convinced, unless there have been some legislative changes that I'm not aware of, that I can order compliance or revoke for another jurisdiction's drug program that we do not have. So, although I think it was voluntary here as much as anything, and I think it should be complied with when you enter it, and they shouldn't waste their resources on our people or anyone else that's in their program. We just got to be really careful legally and jurisdictionally what we order in terms of Senate bill and what we order in terms of drug court, as to being able to jurisdictionally revoke. So at any rate, it appears that she falls within the provisions created by the legislature and those people, whoever they were, that advocated for such a program that became apparently so problematic, but she's still afforded the benefit of that program, or the benefit of a short stint or a dunk before she can be fully revoked. And I have no interest in placing her back on community corrections with this old of a case, partially in disposition because of COVID, but the rest is simply because she couldn't successfully complete her probation that she was doing in the 31st. What I would do if I dunked and reinstated is have her only report to the 13th. And I just don't think we have anything else to offer. Whether she qualified for Senate bill or not, it's expired. And so there's just no more that we can offer her. So she'll do her DOC stint. And Ms. Connor, if you continue to use, you're going to be subject to targeted investigation. You're going to be picked up, you're going to be charged, and you're going to be back in the system. And I don't have your PSI in front of me. You may be a third strike, so you may be presumptive prison as a habitual offender, and not be afforded any of this stuff. So this case needs to be over and done with, and that requires some Department of Corrections time, and you're entitled to a dunk, and I am not interested in having you continue on my case in community corrections any longer. Okay? So you're going to be taken into custody right now. You're going to be processed to go to the DOC for 180 days. And however many days they do or what they do, I have no control of beyond this. I'm releasing you to the Department of Corrections. So if they give you program credit, they used to take people in for 90, 180 days and give you half the time program credit. So I don't know if they're doing that. I have no idea. But the Department of Corrections is going to have to figure that out. That's the maximum time that you'll serve. Okay.
Judge, I need you to announce whether or not you're waiving the bids application fee and any additional attorney's fees for today's hearing.
I'm going to assess the bids on, if she's going to prison right now, can't really find that she can afford to pay additional attorney's fees, but these costs are going to have to. So when you go into prison, I'm supposed to give you a period of time to pay so that your inmate account isn't garnished completely, because the court's found that I have to find, or there has to be a payment plan that you breached. So your payment plan is that you have to have this paid off within the 180 days. If it's not paid off, it's turned over to collections. So if you happen to go to the Women's Correctional Facility at Forbes in Topeka, and they have a work program, and they'll pay you to do some things as long as you're clean, then I would suggest that you save that money to pay off your case. If you don't, then there'll be additional collection costs, and if you go back to work at Casey's, they'll be garnishing your wages. Do you have any questions?
Thank
Okay.
you.
If there's nothing further, we're adjourned. Thank you.
Thank you.
Thank you, everyone.
Be safe, be well, sleep sweet, and much love.